I'm Susan Tierney, and this is Scott Horne, and this is an episode of Ask the Attorney. And Scott, in your law firm and in the title company and in our investment company and all the properties we buy, there are so many different kinds of conveyances. So I thought this would be a great opportunity to kind of look at each one, delve into it so we clearly understand and our audience can understand what all the different deeds and conveyances are.
No, there are. And Susan, you know, when we look at a real estate transaction, especially into the investment world, there are so many different permutations that can be out there, and every deal dictates something different. And sometimes it can be very simple and straightforward, sometimes not quite so simple and straightforward. And then there are various permutations of standard deeds sometimes.
Right. Okay.
But having a knowledge of that does help us navigate our businesses.
Okay. I'm curious, is one deed the same in every different state, or are we going to talk just state-specific Texas deeds?
Well, here as an attorney, you know, I'm more specific to Texas.
Okay.
Now, a deed is a conveyance or a transfer of an interest in real property. Now, is that going to be the same in every state? I think so. Could there be slight differentiations from one state to the next? I'm sure there are in some cases. I'm sure most of it is going to be very, very, very similar out there.
Okay.
And so I always tell everybody to consult that local real estate attorney to make sure they understand this. But for the most part, I think we're going to hold true across the board to a large extent.
Okay. So let's start with one I see all the time, is a general warranty deed.
Okay.
Is that the most popular?
Well, it's the most
popular,
it's the most used. In fact, for instance, here in Texas, in our state promulgated or TREC, Texas Real Estate Commission contract forms, it calls when you're for a general warranty deed to be issued from a seller to a buyer. And that is where basically the seller is warranting title back to the inception of the land. So it goes all the way back.
Okay.
And it is the most common. That's what most people want out there. And again, the seller, when they are providing this deed, you'll note there's a little word in there called warranty, where they're warranting or they're guaranteeing the title to the property. In other words, the seller warrants or guarantees that they have good and indefeasible title to the property.
All the way back to when the property was built?
All the way back. Not when the property was built. The land.
The land. Like that could be hundreds of years.
Or thousands of years, maybe.
Wow. Okay. So that's a general warranty deed. Then what would a special warranty deed be?
Well, a special warranty deed is very similar to the general. The same warranties are being issued, except with a special warranty deed, the seller is only warranting title from the time that they bought the property. Okay?
Okay.
So if they bought the property 5 years ago, they're saying, hey, I have had good and indefeasible ownership interest in this property for the last 5 years. They're not going back to the inception
Why not?
of the land. That's just what they're doing. In other words, they don't want to go all the way back to the beginning of time, per se. They want to say, since I bought this house, I've had good title. Now think about it. When they bought the house 5 years ago,
They got a general
did they get a general at that time? Did they get a special? And did it go back further? But oftentimes, when we're closing these transactions where a special or a general warranty deed is being issued, there is title insurance involved in so many transactions, right? And with title insurance is ensuring that the buyer, you know, is the true owner of that property, subject only to the liens that are on that title commitment. So oftentimes, the way I look at it, if you take a special warranty deed that says, I'm warranting that I've owned this house for the last 5 years, and everything's great, when you incorporate that title policy that guarantees ownership, it kind of helps to extend it going backwards further.
Okay, so the title the title guarantee can go back to the beginning of time?
No, it just is ensuring that the buyer has fee simple ownership of that property.
Okay.
So when you combine the two, it kind of acts as that.
Okay. I don't know why I don't know, that seems weird to me that it goes all the way back or it doesn't.
It's just the way it is.
Just the way it is. And when would you use one over the other? Or does it matter?
You know, if I'm buying a property, I'd prefer to get a general warranty deed if possible.
Okay.
But at the same token, if I have done my title search and I know that the owner of the property who's selling me the home has good and clear title of the property, where you can go back and search things a long time back if you want, I'm okay with a special warranty deed.
Okay.
Especially if I'm closing in a title company where I'm getting title insurance and owner's title policy guaranteeing me that I have feasible ownership. I don't care what kind of a deed I've got. I'm protected by my title company at that point in time.
Okay. So then what is a deed without warranty?
Well, it pretty much is what it says. It's a deed that still conveys the ownership of the property, but now the seller is saying, I'm just not giving you any warranty as to the title. In other words, I'm not guaranteeing you I have perfect ownership. I'm giving you basically what I have. But it is still a full conveyance of the property.
I wouldn't want to sign that.
Well, actually, you wouldn't sign it. You wouldn't want to get it.
I wouldn't want to get it because if they're not guaranteeing it and warranting.
No, but there's a time and place for everything out there. It's all based upon how did that seller obtain the property. You know, what if they obtained the property through a foreclosure? They got a trustee's deed. Maybe they don't want to give you a general warranty deed or even a special warranty deed because they bought it through a foreclosure auction maybe. And there are many other options where a deed without warranty comes into play.
Okay. What about a quick claim deed? Or quit. Is it quit or quick?
It is quit. Q-U-I-T.
Quit. I always thought it was a quick claim and
well,
because it was fast.
I will tell you that half the people out there think it's quick.
Okay.
The other half think it's quick, but it is a quit.
A quit claim deed. So what is that?
So, well, here in Texas, a quit claim deed is going to convey whatever ownership interest you may have in the property. You're not telling the grantee, the person you're transferring property to, that you own anything. You're saying whatever it is I have, you got it. Now, here in Texas, we don't recognize quit claim deeds, but there are some exceptions. Because sometimes in the family courts, we'll see family attorneys, when they go through a divorce scenario, they will issue a quit claim deed from one spouse to the other. Now, why they do that is because they're used to doing it. They haven't called a title company or a title real estate attorney, somebody of that nature, who will say, look, if you can get a quit claim deed, you can get a special warranty deed just as easy. So here in Texas, they don't like quit claim deeds, especially title companies don't. However, if you have a quit claim deed, the longer you've had that deed, the longer it's had time to exist. What happens is that, you know, defenses to it go away because of the statutes of limitations. You know, if you were to have given me a quit claim deed to a property, and let's say 8 years has gone by, will a title company go ahead and say, we'll recognize that? The answer is most likely yes, because of the length of time that's been out there. You've had an opportunity to contest it and say, wait a minute, it's not correct. But sometimes time helps to validate that quit claim deed. Now, every deal is different. And for instance, in the title world, it is not my decision to make on whether that quit claim deed is valid or not. I have one right now, Susan, I'm working on, where the quit claim deed was executed in 2011, 10 years ago. It wasn't recorded. Now, recordation doesn't validate anything. All recordation does is give the world notice that something happened, okay?
Okay.
So once you sign a deed to a property, it's done. So if I gave you a deed to a house, you own the house.
Okay.
The only problem is if you don't go down and record it, the world doesn't know you have it, which means I could go sell the property to somebody else, give them a deed, and if they got down there first, they might win. So it's a protection mechanism, is recordation in a sense, and notice. And so, like anything else, that quitclaim deed, since it wasn't recorded, it doesn't mean, excuse me, that it wasn't valid for the last 10 years. It is. But I don't get the option to make the decision on whether or not an underwriting counsel is going to accept it or not.
So what if they don't accept it?
Well, you get to go back to that party and get a deed.
From 10 years ago?
From 10 years ago.
Wow.
A special warranty deed, a deed without warranty, a general warranty deed.
What if they're dead?
Well, maybe you have to go to their heirs.
Wow.
It gets really messy, which is why it's really important to understand the real estate industry and the documents that are used in it, such as the various deeds, in order to protect all the parties involved.
Right.
You know, while we're talking about family law a little bit, another type of deed that is used in the family law arena is called an oialty deed. O-W-E-A-L-T-Y, oialty.
Never heard of it.
Well, it's a deed where one spouse deeds their interest to the other inside the body of a divorce, in that instance. So it's just another conveyance. Quit claims and oialty deeds are seen often in the family law world. But at the same time, they could be using a special warranty deed just as well. So we're always, whenever I get a chance to talk to a family law attorney, I always try to bring these things up just to help them think through it a little bit.
Okay, so what about, I hear this all the time, contract for deed?
And I have got to tell you, I have been dealing with so many contract for deeds in the last 30 days, I can't even tell you. I have dealt with more in the last 30 days than I have in the last 5 years. And it's like, where do they all come from? But, you know, a contract for deed is the granting of an equitable, but not a legal ownership of the property. So a warranty deed, a special warranty deed, you know, it could be, you could call it a cash warranty deed. Doesn't mean, hey, I paid cash for the property. You don't have to. A general warranty deed can do the exact same thing, but sometimes people put different names with it out there. Whereas, so the deed conveys a legal ownership. A contract deed says you have an equitable ownership, because what it says is that when you as the buyer meet certain obligations, you pay me 100 payments of $1,000, then I will give you a general warranty deed of the property. So in this interim time frame, you have what is called an equitable ownership interest.
So you don't really own the whole thing?
You have an equity interest in it.
Equity interest.
But not a legal ownership interest in it. Now, here in Texas, we're very unique, usually because of our location to the border, where a contract for deed is something we use quite often in an investment transaction, where an investor may be selling to an investor or to someone else who is not an owner-occupant. But in Texas, selling a property to a homeowner who is going to be living in their home as their primary residence using a contract for deed is frowned upon. And there are special provisions in Chapter 5 of the Texas Property Code that in many ways prohibit that or make it extremely onerous to use. In today's world, you'll find most real estate attorneys, at least in Texas, do never recommend the use of a contract for deed in an owner-occupied transaction.
Okay.
I don't mind it in the other. Now, other states, most other states, they can use the contract for deed all day long. It's just here in Texas.
So why? What's different about Texas?
Because we're Texas, baby.
Because of it's the cowboy boots.
It must be the cowboy boots, but I really think it's Mexico. And maybe because we're a bit larger state and there's some investors who haven't done things the right way also. I could sit here and tell you a story on one investor who in 2000 changed all the laws in Texas regarding the contract for deed because he was a bad actor. One person.
One guy.
One guy.
Changed it all.
It was a great mechanism when
Where
done
is
right.
that guy today?
I don't know. He might be in Club Fed. I'm not 100% certain. But anyway, those are things that happen out there. So you have many kinds of deeds, okay?
Okay, so what other kinds of deeds? You have quitclaim, deed without warranty, special, general, contract for deed, oilty?
Oilty.
Oil?
Get your mouth around it just right. Oil.
Oilty?
Oilty.
Deed? I heard of a ladybird deed. What's that?
Ladybird deed. I want to say it's named after Lyndon Baines Johnson's wife.
Is that true?
I believe. I'm not 100% certain, but I don't know where else it could come from. So a ladybird deed is just a colloquial name for an enhanced life estates deed. So what it does is says, I'm going to deed you my house, Susan, and I'm actually going to record it in deed records today. Now, I have the right to live here and do what I wish to with the house for as long as I live here. When I pass away, you become the owner of the property. No probate, no heirship affidavits, no nothing. It's an automatic transfer.
And is it only between husband and wife?
No, anybody.
It can be anybody. On the house that the person lives in?
Sure.
Or could it be any house?
Any house.
Any house. So I could do a ladybird deed on my house to AJ.
You could if you'd like. Whoever AJ is.
That's our video guy over there. I didn't know that. I thought it was only to a husband or a wife.
No.
No.
It's just another mechanism to convey ownership that may help to circumvent probate. No, you can put a property into a trust, and the trust owns it. You have the right to live there, and you might even be the trustee or the beneficiary of this trust that allows you to navigate what you do with the property. But when you pass away, the trust documents then control how that property is disposed of.
Okay. Is that called a life estate deed or a ladybird deed?
Both.
Both. They're the same thing.
Yeah, well, a ladybird deed is basically what we call an enhanced life estates deed here in the Texas marketplace. And I have no doubt, again, in other states, they have life estate deeds just like this.
Okay. So in a life estate deed, you could deed it to somebody and they could live there as long as they live, but when they die?
It's the person who deeds it, so I'm the owner.
Okay.
I deed it to you.
Okay.
I'm allowed to live there as long as I want until I either move out and tell you as such, or when I pass away. But when I pass away, the property transfers to you automatically. But you have to record it, and it has to be recorded before the grantor passes away. So for instance, if you signed the deed on Monday, the grantor dies on Wednesday, and you record the deed on Friday, it's not valid. But if you recorded it on Monday or Tuesday, it would be valid.
Wow. So somebody could die in that time date. Right?
So the important part is if you're going to do that, get it done. We have been.
We have been. We don't want to talk about that though, do we? Or do we?
No.
Okay. So do all deeds have to be recorded?
Well, I mentioned earlier that recordation is only notice. Okay?
But wouldn't it make it easier if you're trying to sell the property or?
Well, absolutely it does.
Okay.
But your question was, do they have to be recorded? And the straightforward, simple answer is no, they don't. A deed is valid upon execution and delivery. Okay?
But you would recommend it.
Yeah, and by the way, with consideration if it's a sale. If there's no consideration, you just can't give somebody a house. Now you can gift it to them. By the way, there is also, and we'll talk about this, a gift deed where you can actually gift something to somebody. So again, that would be a probate or an estate planning mechanism.
It wouldn't just be a will?
That can be used. Well, no, but you can do a gift deed for conveyance purposes out there.
Interesting. Okay.
But let me just stop. Recordation. Recordation is for notice to the world. It does not validate. In other words, it's not execute and deliver a deed to somebody, and if you're selling, pay for it, and then record to validate, it's already valid. But to protect yourself, to show the world, I own this property, yeah, you want to record it. That's our protection mechanism.
Okay. Now, all these deeds, because, you know, we know a lot of investors like to go the cheap route, right?
No.
Yes,
I didn't know
they do.
that.
So, if...
Don't you always call me cheap?
Yes.
Okay.
But you're smart when it comes to legal stuff because you're a lawyer. You would always do the right thing. But a lot of them, they go onto the internet and they pull off forms and they create their own deeds. Or they create their own disclosures or their own contracts. Do you see that, people doing stuff like that? And is that legal?
Well, is it legal? Yes.
It is?
Sure.
Oh.
Now, is it the right thing to do? Don't know. Everybody deals a bit differently. Maybe you have somebody who's very knowledgeable of this and they know exactly what they're getting, and they're actually going online, pulling off an appropriate document for their state. And, you know, don't bring a deed from Georgia to Texas, okay?
Right.
Or vice versa, or whatever it might be. We want to make certain that we have a Texas or a deed that will be valid in the state of Texas. And really, it's just making sure that it has the proper information in there for conveyancing purposes. Now, can you do that? And can you sign it and record it and be just fine? Sure. Is it recommended? Well, no, it's not. And it's not about trying to make money for somebody, but it's really what we want to do is make sure people protect themselves and do things right. Because so often I see people who, they grab various forms online, or they get it from their neighbor or their other investor buddies, or it might be, and it is not appropriate or applicable to the particular state that they're in. It's just, you know, I've seen Georgia contracts used here in Texas, for instance. And you're reading through it, and it's like the laws of the state of Georgia shall govern. And it's like, what? And there's various provisions that really don't apply to Texas. For the most part, it may. But you don't want to go through that mess.
Okay.
Use the right forms. And if you can, go to someone who's knowledgeable, preferably a good real estate or title attorney who can help you through those transactions. And make sure you're using the right documentation.
Okay. How much does a deed cost, and are all these different prices, or is a deed is a deed and you pay the same?
No, they're about the same, but no, you don't just prep one. You have to ask questions. You know, what is the seller trying to do? What does the buyer want? What does the contract say? Do they even know which way to go, one way or the other? And most people have no idea the things we discussed. They think they do, but they really don't. And so what we try to do is at least take a moment to speak with them about what their process is. In other words, just don't send me an email and say, please prepare a general warranty deed for XYZ property. I'm not just going to do that. I'm going to stop, call them, hey, what you got going on? Let's walk through it real quick, then prepare it.
Okay.
And it's how you make sure you do things the right way.
Right. But do most people even know to tell you what they want, or do you suggest
Well, that's why
it?
sometimes we want to talk to them, figure out what the transaction is they're doing, so we can guide them properly, and then prepare that paperwork. Now, normally, when we do all that, a deed's usually about $150.
Yeah.
Maybe a fuzz less, who knows, based on the deal. Now, I'm going to take us a step further and talk about a few more deeds, okay?
Okay.
You know, there's another deed that we use. It's called an assumption warranty deed, where the premise of that deed is where the buyer is assuming the debt on the property. Now, notice I said assuming. I did not say buying subject to. Very different, right, as you well know. So there's a connotation when you use an assumption warranty deed that they're assuming that loan in some format, even though they may not go down and assume it. There's also...
Because I thought you couldn't assume a loan.
You can, but you must assume with
You
qualification.
have to qualify.
Right. So another deed that's in that same genre is one that we call a warranty deed to secure performance. Now, when we're handling a subject to transaction, we don't want to use an assumption warranty deed because we're not assuming the loan, right?
Right.
We want to use a deed of trust to secure performance because you're giving me a deed, and it's a warranty deed with vendor's lien to secure performance. So the vendor's lien, meaning the seller's lien to us, is there to secure our performance of paying the underlying debt in a timely fashion.
Okay.
Now, obviously, we're going to incorporate other documents with that. A deed of trust to secure assumption, if we're doing the assumption transaction, or maybe a deed of trust to secure performance on the subject to transaction. So little nuances for each transaction. And unfortunately, I see a lot of investors mix and match these along the way.
Okay, warranty, say that again.
There's an assumption warranty deed, and there is a warranty deed with vendor's lien to secure assumption.
Warranty deed with vendor, and who's the vendor? The seller?
The seller.
The seller's the vendor.
Or the lender.
So the warranty deed, say that again, with?
It is a warranty deed with vendor's lien.
Vendor's lien.
To secure assumption. So when we were talking about other basic deeds, a general warranty deed, a special warranty deed, a deed without warranty, those could all have a vendor's lien associated with it, meaning that there is a loan associated with the transaction.
Okay.
And you're
is that a separate lien, all in, like you do a warranty deed and a separate vendor's lien?
No, it's
or
in the
is it
same
all
document.
In one?
It's in one
all
document. So you could have a general warranty deed, connotates you paid cash for the property, but not always, because you might have a mortgage that is separate. And the lender doesn't require a vendor's lien in the deed. A vendor's lien here in Texas is a subordinate lien to a deed of trust, as it would be in most states as well. Now that's getting a little bit deep, what we're talking about.
In the weeds a little.
But you'll see some of these things out there.
Okay.
You'll see this a special warranty deed or a special warranty deed with vendor's lien. A general warranty deed or a general warranty deed with vendor's lien. Now if you see a cash deed, that's a general deed without a lien on the property, obviously, because you paid cash.
What about on all these deeds, they had to be signed in front of a notary?
Yes, they do.
Okay.
In order to record a document, you have to have it notarized.
Notarized.
So, is a deed still valid with just a signature on it? Yes.
It is.
But the problem now is who is going to validate that you signed that deed? That's what the notary is doing. They're validating that you signed that deed in front of them. And they identified whom you are through your driver's license or some other ID of that nature and took care of that. But to record that deed, if you just have it signed only, you're not going to be able to record it. It has to be notarized because the county wants to ensure that it's a valid signature.
Okay. Very interesting. I learned something.
Well, great.
Okay. Well, thank you. And did we miss any? We got all the deeds?
I think we got pretty much of them, but there's a lot out there,
But
though.
would you say 75% of what you do are general warranty deeds?
No.
No. Give me in your law firm the percentage of, you do 50 general, special, or you do
no.
just all over the
We
map?
do, and so for us, we do a huge number of warranty deeds with vendor's lien to secure performance. Very few assumption deeds. Next is special warranty deeds, then general warranty deeds. The next one, if you want to go one more down the line, it's going to be from there the deed without warranty. We don't do any quitclaim deeds. In fact, we try to avoid that like the plague.
And the contract for deed. We don't do those.
Only in investor transactions, and we do those rarely.
Okay. Okay, well, that was very informative. Thank you, Scott. We'll see you on the next episode of Ask the Attorney.